Good morning everyone, we are group 7 and today we are going to present our presentation which is about the Republic Act number 544 as amended by RA 1582. Article 1, Title of the Act and Definition of Terms. Section 1, Title of Act. This act shall be known as the Civil Engineering Law. Section 2, Definition of Terms. The practice of civil engineering within the meaning and intent of this act shall embrace services in the form of consultation, design, preparation of plans, specification, estimates, erection, installation and supervision of the construction of streets, bridges, highways, railroads, airports, and hangars, portworks, canals, river and shore improvement, lighthouses and dry docks, buildings, fixed structures for irrigation, flood protection, drainage, water supply, and sewerage work, demolition of permanent structure and tunnels. The enumeration of any work in this section shall not be construed as including any other work requiring civil engineering knowledge and application. The term civil engineer as used in this act shall mean a person duly registered with the Board for Civil Engineers in the manner as hereinafter provided. Article 2, Board of Examiners for Civil Engineers. Section 3, Composition of Board. The first members of the board appointed under this act shall hold office for the following terms: 1 member for 1 year, 1 member for 2 years, and 1 member for 3 years. Each member of the board shall qualify by taking the proper oath of office before entering upon the performance of his duties. Any member of the board may be removed by the President of the Philippines upon recommendation by the Professional Regulation Commission or PRC for neglect of duty, incompetency, malpractice, unprofessional, unethical, immoral, or dishonorable conduct after having been given opportunity to defend himself in a proper administrative investigation provided. Section 4, Powers and Duties of the Board. The Board for Civil Engineers is vested with authority conformable with the provisions of this act to administer oaths, issue, suspend, and revoke certificates of registration for the practice of civil engineering, issue certificates of recognition to the civil engineers already registered under this act for advanced studies, research, and specialized training in any branch of civil engineering subject to the approval of the PRC to investigate such violation of this act and the regulation thereunder as may come to the knowledge of the board, and for this purpose issue subpoena and subpoena adduces tecum to secure appearance of witnesses in connection with the charges presented to the board, to inspect at least once a year educational institution offering courses in civil engineering, civil engineering works, project, or corporation established in the Philippines, and for safeguarding of life, health, and property, to discharge such other powers and duties as may affect ethical and technological standards of the civil engineering profession in the Philippines. Section 5, Qualification of Board Members. Letter A. Be a citizen and resident of the Philippines. B. Be at least 30 years of age and of good moral character. C. Be a graduate of civil engineering from a recognized and legally constituted school, institute, college, or university. Be a registered civil engineer duly qualified to practice civil engineering in the Philippines. Have practiced civil engineering with a certificate as such for a period of not less than 10 years prior to his appointment. Not be a member of a faculty of any school, institute, college, or university where civil engineering course is taught, nor have a passionary interest in such institutions. No former members of the faculty of any school, institute, or university where civil engineering is taught can become a member of the board unless he had stopped teaching for at least 3 years consecutive years. Section 6. Fees and compensation of board. The Board for Civil Engineering shall charge for each application for examination the sum of 100 payable to the collecting and disbursing officer of the PRC upon filling of said application. For each certificate of registration, 50 pesos. Each member of the board shall receive a compensation of 15 pesos for each applicant examined. A civil engineering in the service of the government of the Republic of the Philippines, appointed as member of the board, shall receive the compensation as herein provided. In addition to his salary in the government, all authorized expenses of the board, including the compensation provided, shall be paid by the collecting and disbursing officer of the PRC out of such appropriation as may be made for the purpose. Article 3. Examination and registration. Section 8. Examination requirement. All applicants for registration for the practice of civil engineering shall be required to pass a technical examination as hereinafter provided. Section 9. Holding of examination. Examination of candidates desiring to practice civil engineering in the Philippines shall be given in the city of Manila of each year, provided that such day do not fall on official holidays. Otherwise, the examination shall be held on the days next following. So, dito sa section 8, kailangan daw is required na mapapasa ang technical examination o yung ESC, Engineering Service Commission, para maging qualified sa board ng civil engineer. Section 10. Subjects of examination. Applicants for certificate of registration as civil engineer shall be examined in the discretion of the board on the following subjects: mathematics, including algebra, plane and spherical trigonometry, analytics, descriptive and solid geometry, differential and integral calculus, and rational and applied mathematics, hydraulics, surveying, including highway and railroad surveying, plane, topographic and hydrographic surveying, and advanced surveying, design and construction of highways and railroads, masonry structure, wooden and reinforced concrete buildings, bridge, towers, walls, foundation, ports, sanitary engineering works, water supply systems, dikes, dams, and irrigation and drainage canals. Section 12. Qualification for examination. Any person applying for admission to the civil engineering examination as provided shall, prior to the date of the examination established to the satisfaction of the board that he has the following qualification: be at least 21 years of age, be a citizen of the Philippines, be of good reputation and moral character, be a graduate of a 4-year course in civil engineering from a school, institute, college, or university recognized by the government or the state wherein it is established. Section 13. Oath of Civil Engineers. All successful candidates in the examination shall be required to take a professional oath before the Board of Civil Engineers or other government official authorized to administer oaths prior to entering upon the practice of civil engineering profession. Section 14. Seal and use of seal. All registered civil engineers shall obtain a seal of such design as the board shall authorize and direct, provided, however, that the serial number of the certificates issued by the board shall be included in the design of the seal. Plans and specifications prepared by or under the direct supervision of a registered civil engineer shall be stamped with said seal during the life of the registrant certificate, and it shall be unlawful for anyone to stamp or any document with seal after the certificate of registrant named thereon has expired or has been revoked, unless said certificate shall have been renewed or reused. Section 15. Exemption from registration. Number 1. Registration shall not be required of the following person: A. Officer or enlisted men of the United States and Philippine Armed Forces and civilian employees of the government of the United States stationed in the Philippines while rendering civil engineering services of the United States or Philippines. B. Civil engineers or experts called by the Philippine government for consultation or specific design and construction of fixed structures as defined under this Act, provided that their practice shall be limited to such. 2. Any person residing in the Philippines may make plans on a specification for any of the following. Letter A. Any building in chartered cities or in towns with building ordinance not exceeding the space requirement specified therein, requiring the service of civil engineers. B. Any wooden building enlargement or alteration which is to be used for farm purposes only and costing not more than 10,000 pesos. C. Provided, however, that there shall be nothing in this Act that will prevent any person from constructing his own residential house, utilizing the service of a required for the purpose, without the use of a civil engineer, as long as it does not violate local or. Number 3. Nor shall anything in this Act prevent draftsmen, student, clerk, or work superintendents and other employees of those lawful engaged in the practice of civil engineering under the provision of this Act from acting under the instruction, control, or supervision of their employees. Number 4. Nor shall anything in this Act prevent any person who prior to the approval of this Act have been lawfully engaged in the practice of maestro de obras to continue as such, provided they shall not undertake the making of plans or provision for the following classes of work. Letter A. A building of concrete, whether reinforced or not. B. Building of more than 2 stories. C. Building with frames or structural stills. D. Building of structures intended for public gathering or assemblies such as theaters, cinematographs, stages, churches, or structures of like nature. Section 16. Refusal to issue certificate. The Board for Civil Engineers shall not issue a certificate to any person convicted by a court of competent jurisdiction of any criminal offense involving moral or to any person guilty of immoral or dishonorable conduct or to any person of unsound mind. In the event of a refusal to issue a certificate to any person, the board shall give to the applicant a written statement setting forth its reason for such action, which statement shall be incorporated in the records of the board. So dito sa section 16, kapag ikaw ay na-convict ng court o nakagawa ka na any criminal offense na involving unmoral turpitude or guilty ka sa mga immoral or dishonorable conduct, ikaw ay makakatanggap ng refusal to issue certificate. Section 17. Suspension and revocation of certificates. The board shall have the power, after due notice and hearings, to suspend or revoke the certificate of registration for any cause mentioned in the preceding section. Section 18. Reissue and replacement of certificates. The board may, after the expiration of 1 year from the date of certificate of registration is revoked and for reason it may deem sufficient, and entertain an application for a new certificate of registration from the registrant concerned. Such application shall be accomplished in the same form prescribed for examination, but the board may, in its discretion, exempt the applicant from taking the requisite examination. Section 19. Transitory Provision. All graduates in civil engineering from a school, institute, college, or university recognized by the government who have passed the civil service examination for senior civil engineer and have been practicing or employed in the government as such during 5 years are exempted from taking examination. Article 4. Enforcement of Act and Penal Provision. Section 20. Enforcement of the Act by officer of the law. It shall be duty of all duly constituted all officers of the national, provisional, city, and municipal governments or any political subdivision thereof to enforce the provision of this act and to prosecute any person violating the same. Section 21. Registration required. Unless exempt from registration, no person shall practice or offer to practice civil engineering in the Philippines without having obtained the proper certificate of registration from the Board for Civil Engineers. Section 22. Penal Provision. Any person who shall practice civil engineering in the Philippines without being registered in accordance with the provision of this act, or any person who shall impersonate any registrant civil engineer of different name, or any person who shall attempt to use a revoked or suspended certificate of registration or any person who shall violate any of the provision of this act shall be guilty of a misdemeanor and shall upon conviction be sentenced to a fine of not less than 500 pesos nor more than 2,000 pesos to suffer imprisonment for a period of not less than 6 months, not more than 1 year, or both in the discretion of the court. So dito sa section 22 penal provision, ang sino mang civil engineer na mahuhuli na nag-impersonate o gumagamit ng mga iba't ibang pangalan or mga civil engineer na nagbibigay ng mga maling impormasyon o sinisiraan ng mga kapwa civil engineer ay maharap sa parusang pagbumulta na hindi bababa sa 500 pesos pero hindi rin tataas ng 2,000 pesos. Or pwede silang makulong ng 6 months, minimum 6 months, pero hindi tataas ng 1 year na pagkakakulong. O pwede din naman na parehas itong ipataw depende sa Korte Suprema. Article 5, Miscellaneous Provisions. Section 23, Preparation of plans and supervision of construction by registered civil engineer. It shall be unlawful for any person to order or otherwise cause the construction, reconstruction, or alteration of any building or structure intended for public gathering or assembly such as theaters, stadia, churches, or structures of like nature, and any other engineering structures mentioned in section 2 of this act, unless the design, plans, and specifications of same have been prepared under the responsible charge of and signed and sealed by a registered civil engineer, and unless the construction, reconstruction, and alteration thereof executed under the responsible charge and direct supervision of a civil engineer. Plans and designs of structure must be approved as provided by law ordinance of a city or province where the said structure is to be constructed. Section 26, Roster of Civil Engineer. A roster showing the names and places of business of all registered civil engineers shall be prepared by the Commissioner of PRC periodically but at least once a year. Copies of this roster shall be placed on file with the PRC and furnished to all department heads, mayor of all charactered cities, to the Director of Public Works, to such or the bureaus, government entities or agencies, and municipal and provincial authorities as may be deemed necessary, and to the public upon Section 27, Repeal. All laws, part of laws, order, ordinance, or regulation in conflict with the provision hereof, including parts of Act number 2985 as amended as pertains to the practice of civil engineering, are hereby repealed except the provision of Act number 3159 amending Act number 2985 pertaining to the practice of maestro de obra. Section 28, Construction of Act. If any part or section of this Act shall be declared unconstitutional, such declaration shall not invalidate the other provision hereof. Section 29. Effectivity. This act shall take effect upon its approval. SIAP Document 102. Uniform General Condition of Contracts of Private Construction. Section 1. Definition and Documents. Article 1. Definition. Act of God or force majeure shall mean an event beyond the reasonable control of the owner or the contractor, as the case may be, and which is unavoidable notwithstanding the reasonable care of the party affected, and shall include, without limitation, of the following. Letter A. War, hostilities, or warlike operation, whether a state of war be declared or not. Invasion, act of foreign enemy, civil war. Letter B. Rebellion, revolution, insurrection, mutiny, or usurpation of civil or military government, riot, civil commotion, terrorist act. And D. Strike, sabotage, lockout, embargo, import restriction, port congestion, lack of usual means of public transportation and communication, industrial dispute, shipwreck, shortage or restriction of power supply, epidemics, quarantine, earthquake, landslide, volcanic activity, fire flood, lightning or other inclement weather condition, nuclear and pressure waves, shortage of labor, materials, or utilities were caused by circumstances that are themselves force majeure. 1.02 Advertisement or invitation to bid refers to the notice published by the owner or the invitation issued to the prospective bidders, giving information as to the nature of the proposed project, condition for the insurance of contract documents, date of bidding, and information that would give the contractor a general idea of the magnitude and extent of this project. Article 1.03 Agreement is the term used to describe the agreement signed by the owner and the contractor, excluding the contract documents which are attached thereto. Article 1.04 Bid is the tender or proposal or quotation or offer of the bidder to perform the work described in the contract, which in the form and substance complies with the instruction to bid. Article 1.08 Breakdown of work and corresponding value is a listing of the different parts of the work, indicating each part and its corresponding value. Article 1.09 Change order is a written order to the contractor issued by the owner after the execution of the contract, authorizing a change or variation in work or an adjustment in the contract price or contract type. Article 1.010 Contract is the term used to describe the agreement and the contract document. Article 1.11 Contract documents are the document attached to the agreement identified therein as contract documents, including all addition, deletion, and modification incorporated. A. Special provision or condition. B. General condition. C. Specification. D. Drawings. And E. Other bid documents. Article 1.12 Contract price is the amount in money or other consideration to be paid by the owner of the contractor for the execution of the work in accordance with the contract. 1.13 Contractor is the person or firm duly registered and licensed by the Philippine Contractors Accreditation Board whose proposal has been accepted, to whom was awarded the contract to execute the work. Article 1.40 Costs. Means on expenditures properly, whether on or off the site, including overhead and other charges properly allocable, but does not include any allowance for profit. Article 1.15 Drawings. A graphical presentation of the work. They include all supplementary details and shop drawings. Article 1.16 Final Payment. Refers to the payment of the final progress billing and all approved claims, including but not limited to variation in the work, contract price adjustment and or escalation, acceleration of work, and other. It does not include the retention of money. Article 1.17 Guarantee Bond is the approved form of security furnished by the contractor and is surety as a guarantee of the quality of the materials provided, the equipment installed, and the workmanship performed by the contractor. 1.18 Instruction to bidders refers to the list of instructions regarding the manner bids are to be prepared and the condition for the award of the contract. 1.19 Laws refer to all laws, ordinances, and other government rules and regulations applicable to the project and to its execution. Article 1.20 Owner is the person or entity or authorized representative thereof who signed the contract as owner. Article 1.21 Owner's representative refers to a person or entity commissioned by the owner or authorized in writing by the owner to act on his behalf. Article 1.25 Specification are the written or printed description of the work to be done, describing qualities of the material to be used, the equipment to be installed, and the mode of the construction. Article 1.26 Special provision or condition are instructions which are used prior to bidding to supplement and modify the drawings or general condition of the contract. 1.27 Subcontractor is a contractor duly registered and licensed by the Philippine Contractors Accreditation Board having a direct contract with the contractor and who act for or in behalf of the contractor in executing any part of the contract. Article 1.30 Time limit or completion time is the period of the time allowed by the contract for the completion of the project or any stipulated portion. Article 2 Execution, correlation, meaning of terms, and intent of documents. 2.01 Intent of contract. The intent of contract is to include all labor and materials, equipment, and transportation necessary for the proper execution of the work. Standard of conduct. Each party of the contract acknowledge that in the exercise of his rights and the performance of his duties, he must act with justice, give the other parties due, and observe honesty and good faith. Of contract. In case of conflict between the provision of the agreement or any contract document or between the provision of the contract document and the provision of another contract document, or in case of the discrepancy, defective description, error, omission in the contract. Rule number 1. The agreement and the contract documents shall be taken as mutually explanatory of one another. The various provisions of the contract shall be interpreted together, contributing to the doubtful ones in that sense which may result from all them taken jointly. So, Rule 2. The provision of the Civil Code of the Philippines on the interpretation of contract and the rules of court on the interpretation of documents shall be applied. Rule 3. For the conflict between or among the provision of the agreement and or the contract documents cannot be resolved by rules 1 and 2, it shall be understood that, so letter A, the detailed drawings shall prevail over the general drawings. B, words and figures shall prevail over the drawings. C, words shall prevail over figures in contract documents. D, written dimensions shall prevail over measured. Rule number 4. Where the conflict cannot be resolved by applying Rule 3 or where Rule 3 does not apply, the conflict shall be resolved by giving precedence to the agreement or the provision of contract document higher in order of priority among the various documents which comprises the contract. The order of the priority among these documents shall be as follows. Letter A. Agreement as modified by notice by award of contract. B. Instruction of bidders and any amendment. C. Addenda to bid documents. D. Specification. E. Drawings. F. Special condition of contract. G. General condition of contract. H. Other contract documents. I. Other documents forming part of the contract attached or incorporated therein by Rule 5. For there is the discrepancy, defective description, error, or omission in any contract document, the contract document shall be interpreted, shall be complementary to each other. Rule 6. The apparent silence of drawings, specification, or any other contract document as to any detail or the lack of detailed description concerning any part of the work shall be understood to mean that good and accepted construction practice in accordance with the usage or custom of the place shall be followed. Article 2.04. Conformity to the contract. Letter A. If there be a variance between the drawings and the specification, the provision of the specification shall control. In case of conflict between the general condition or any modification thereof and the detailed specification requirements, the detailed specification requirements shall control. B. The owner shall be fully responsible for adequacy of the design, for the sufficiency of the drawings and specifications. The complete requirement of the work shall be set forth in drawings and specification to the supplied by the owner. Article 2.05. Meaning of terms. Letter A. Approved, direct, and acceptable. The words approved, direct, and acceptable, or words of like import, shall mean approved, directed by, or acceptable to the owner. Furnish. The word furnish shall be understood to mean purchase and or fabricate and deliver to the job site or other location when so designated. C. Install. The word install shall mean to build in, mount in position, connect or apply any object specified ready for the intended in provide. The word provide shall be understood to mean furnish and install, required or necessary. The words required or necessary shall mean as required or necessary for the complete execution of the portion of the work. Then FPRC, Professional Regulation Commission. Article 2.06 Timely exercise of administrative responsibilities. Whenever under the contract, the owner is required to exercise his discretion by letter A, giving his decision, opinion, or consent. B. Expressing his satisfaction and approval. C. Determining the value. D. Providing drawings. E. Supplying equipment or materials. F. Otherwise, taking action which may affect the work contractor's timely completion of the work.
Article 3. Drawings and Specifications. In this article, it is said that there are 3 sets of drawing that the owner is free of charge, and all other drawings as required by the contractor will be furnished and will cost of production. All drawings must have a clear specification and measurements by scale. Drawings and specification made by the owner must be explained to the contractor. He shall provide necessary direction and explanation. Upon inspection, the contractor shall report immediately the discrepancy upon its discovery. Detailed drawings and instructions for Article 4. The owner shall provide additional detailed drawings and instructions because detailed information is essential for proper interpretation and execution of work. Article 5. Shop Drawings. Shop drawings is a set of drawings produced by the contractor. Prefabrication is practice of assembling components of a structure in manufacturing site and transforming complete assemblies to the construction site where the structure is to be located. Shop drawings shall be dated and must contain essential data like project name, location, and other. It shall have letter of transmittal containing the name of the project, the contractor's name, number of drawings, titles, and other permanent data. Shop drawings are in 3 sets. The approved drawing is identified by the owner and the other will be revisioned. Section 2. Laws, Regulation, Site Condition Permits, and Taxes. Article 6. Laws and Site Conditions. Laws refers to all laws, ordinances, and other governmental rules and regulations applicable to the project and to its execution. If the contractor performs work contrary to such laws or regulation, he shall bear all additional costs arising therefrom. Before the work progress starts, the contractor shall visit the project site and make his estimations before bidding and awarding the contract. As the final occupancy permit, the contractor shall secure it, but he shall not be responsible to the owner if the license is not issued or there was delay in its issuance for reasons that are not attributed to the contractor's fault. The owner is responsible for the accessibility of his project site. Therefore, he shall provide physical characteristics of the site and its way. Boundaries made by the owner shall be certified by a surveyor. Section 3. Equipment and Materials. Article 8. General. When we say conform, it must comply with the rules, standards, and laws. It is need to avoid future conflicts or to minimize it. In construction, it is hard to avoid conflicts like damages. Therefore, it is borne by the contractor because it is his responsibility. Article 9. Equipment. Contractor shall provide list of equipment essential for the work in order to establish standards quality. Equipment substitution shall have a complete list provided as it may be required by the owner. Article 10. Materials, fixtures, appliances, and fitting furnished by the contractor. Sample materials are accompanied with permanent data for the approval of the owner. Sample materials shall be specified in accordance with its quality. Material substitution is not permitted without the owner's approval. Materials used without approval shall be in the contractor's responsibility. Testing of materials is required, and samples shall be as many as it needed for testing. Materials shall be specification and government standards. Materials quality shall be in best grade. Article 11. Materials, equipment, fixtures, appliances, and fittings furnished by the owner. All materials and equipment shall be provided with a construction schedule approved by the owner. The provided material by the owner shall be accepted and shall be used until the desired time directed by the owner. It shall not be tested unless the owner directs and shoulder the testing cost. The patented material shall be paid with the contractor, and he shall defend the owner if there would be violation of the patent. Manufacturer's information supplied by the contractor shall be used in accordance with manufacturer's direction. Manufacturer's information supplied by the contractor shall be used in accordance with the manufacturer's direction and shall submit specified number of copies to the owner. Section 4. Premises and temporary structures. Article 14. Use of premises. Premises are land and buildings together considered as a property. The materials shall not hinder the work progress on the working site. The contractor shall limit the operations mandated by the law or with the owner's direction. The contractor is responsible for the safety in the working site, ensuring the safety of everyone, and any damage or loss is with the contractor's responsibility. Article 15. Temporary structures and facilities. Whenever how big or small the project is, there is always an office and accommodation shall be provided. Project site shall have an adequate temporary office and contractor's building that shall have water, light, and telephone. A project site shall also have a temporary housing for workers, provided that there are also basic necessity like water and light. Areas are determined by the owner, and if not, the contractor may use his discretion in determining such areas in consultation with the owner. Section 5. Protection of work and owners. Article 16. Protection of work and owners' property. Ensuring safety is a must by setting and enforcing standards. The contractors shall take all well-grounded measures to protect from damages. However, damages caused by the contractor's responsibility is shouldered by him, except those caused by the owner's agents and or causes considered act of God. Article 17. Protection of adjacent property and existing utilities. Adjacent property means all lands adjoining and surrounding the site, including streets, sidewalks, bridges, and buildings. It is contractor's responsibility to protect it from any damage, and he shall shoulder expenses if damages will occur in any manner by his act or neglect. Article 18. Protection of life, work, and property during an emergency. Change order is an industry term or an amendment to a construction contract that changes the contractor's scope of work. Even without a special instruction or authorization from the owner, the contractor shall act to prevent or minimize damages such as threatened loss or injury. Emergency work such as first aid is treated as one. However, it is not considered when the emergency is caused by his fault or negligence. Section 6. Labor, Work, and Payments. Article 19. Labor. The contractor shall only employ competent and duly qualified professionals to supervise and execute the work. Any employee who is incompetent or obstruct the progress shall be terminated as per written request of the owner. Article 20. Work. Before the progress starts, whenever their method appears to be inefficient or inappropriate for the owner's point of view, he may order the contractor to increase their efficiency to improve their system of operation. The contractor must comply with such order. When laying out the work, the contractor shall carefully guard and preserve at all stakes, unless such stakes are rendered useless and shall be replaced at his expense by the contractor. Work inspections can also be done by the owner. He shall have the access to work at all times. Upon discovery, defective work shall be condemned by the owner and immediately removed in accordance with the drawings and specifications.
Article 21, Time of Completion. Completion time. So dito, if yung constructor ay nakatanggap na ng notice galing sa may-ari para simulan yung trabaho, so such shall begin with 7 days from receipt of the notice to proceed, unless kung yung notice na natanggap niya is for a later date pa para sa pagsisimula ng trabaho. So, sa extension of time naman, the contractor shall be entitled to an equitable adjustment of completion time where the contractor is nagkaroon ng hadlang or delay in the prosecution or completion of work. So, sa article number 22, payments, nakapaloob dito yung breakdown of contracts amount. Sa breakdown of contract amount, the contractor shall within 15 days from the receipt of notice to proceed. Tapos nakapaloob din dito yung request of payment. So dito naman, binibigyan ng contractor na mag-submit periodically but not more than one each month a request payment for work done, and authorized deduction from the value of complete work. So yung owner, pwede siyang mag-deduct any payment due to, for example, the estimate cost of defective work not remedied. Next is condition relative to payment. So dito naman, the owner shall estimate the value of work na natapos ng contractors using the basis schedule stipulated in a breakdown of work and corresponding values. Conditions relative to payment. So dito naman, within 30 days after a receipt of payment request from the contractor, owner shall pay the amount as certified. So, dito sa payment of unpaid labor, subcontractors, and supplier, dito naman yung contractor shall pay punctually lahat ng workmen niya or yung tauhan niya, not less than such rate as provided by law. So, dito naman sa payment over 90%, no payment shall be made in excess of 90% of the contract price. So next is other requirements before final payment. The contractor shall submit some documents aside from those which may be provided in the contract. So next is accept and final payment. So dito naman, the owner shall then accept for causes herein specified pay to contract within the period stated in the article. So, dito naman sa correction of work before or after final payment, acceptance by the owners of work of the contractor shall relieve the contractors of liability of any defect in the work. So, unless na the defect is hidden and the owner could not have discovered the defect, even the exercise of the reasonable diligence. So, dito naman sa release of retention, the amount retained by the owner under the provision of the contract shall be released not later than the expiration of the period of making good known defects as provided in Article 20. Section 7, Contractor, Separate Contractors, Subcontractors Relation. Article number 23. Separate contracts with other contractors. The owner may perform outside of the contract scope of work or award separate contract to other contractor if the contractor claims that delay, damage, or additional cost is involved as a result. Ang contractor ay dapat gumawa ng paraan or paghahabol ayon sa kontrata. Ang may-ari ay dapat magbigay for the coordination of the work performed by the owner and or each separate contractor with the work of the contractor. Article number 24. Contractor Separate Contractors Relations. Nakapaloob dito sa article na to yung storage of materials and work coordination, cutting, patching, and digging, defective work by separate contractors, damage caused by contractors to separate contractors, damage caused by separate contractors to the contractors. So, storage of materials and work coordination. So, dito naman, ang contractor shall be to extent possible. Kayang bayaran ang ibang mga contractor in a reasonable opportunity for introduction and storage of their materials at sa patupad ng kanilang gawain. At dapat din na maayos na kumonekta at makipagtulungan sa owner's effort to coordinate his work with that other contractors to minimize interference. So, dito naman sa cutting, patching, and digging, yung contractor is gagawin niya lahat ng cutting, pitting, or patching of his work that may require to make its several parts come together properly and fit it to receive or reasonable implied by the drawings and specification for the completed structure. So, for defective works by separate contractors naman, if any parts of contractor works depends for proper execution or resort upon the work of any other contractors, yung contractors kailangan ay i-inspect niya to and agad na i-report sa may-ari. So, for damage caused by separate contractors to contractor, kung ang sino mang magkahiwalay na contractor ay magdulot ng pinsala sa trabaho ng kapwa contractor, then the owner shall hold the harmless the contractor in a respect hereof. Article number 25. Subcontract. Nauunawaan at napagkasunduan na walang bahagi ng trabaho ang dapat na sublet or subcontracted nang walang pahintulot ng may-ari. However, any parts of thereof or any specialty work therein may be sublet or subcontracted subject to the provision of Article 25.2 and 34.3. Ang pahintulot ng may-ari sa pakikipag-ugnay ng contractor ng isang subcontractor sa pamamagitan nito ay hindi lilikha ng anumang contractual na ugnayan sa pagitan ng subcontractor at ng may-ari. Contractor's responsibility. So, contractor's responsibility naman is the contractor agrees na siya yung responsable sa mga pagkakamali or mga kilos ng kanyang subcontractors sa may-ari, and the person either directly or indirectly employed by them as he is for the acts and omission of person directly employed by him. Section 8. Suspension of work and termination of contract. Article number 26. Contractor's right to suspend work or terminate contract. The contractor contractor may suspend work or terminate the contract upon 15 days written notice to the owner for any of the following reason. So number one reason is if an order of any court or other public authority caused by the work to be stopped or suspended for an aggregated period of 90 days through no acts or fault of the contractor of his employees. And then, pangalawa is kung nabigo ang may-ari na bayaran ang kontraktor ng naaprobahang kahilingan para sa pagbabayad na itinadhana sa Article 22.5. Kung ang may-ari ay nabigo na bayaran ang kontraktor ng anumang halaga sa loob ng 30 araw pagkatapos ng paggagawad nito sa pamamagitan ng arbitrasyon. Kung sinuspinde ng may-ari ang trabaho nang walang makatarungang dahilan na higit sa pinagsamang panahon ng 15 araw nang walang pahintulot ng kontraktor. If the owner fails to deliver at the construction site furnish construction materials and equipment for the scope of work along the critical path beyond 15 days after its scheduled date for a delivery as provided for in the contract. Next is if approval of variation orders for additional works along the critical path is delayed beyond 15 days after submission for approval by the owner or by his duty designated representative. If the suspension is necessarily for the proper execution of the work or by the reason of weather or other conditions affecting the safety of works and the contractor's workers, the contractors may request the owner to suspend the work in ordinance with the applicable provision or Provision Act 27.2. Ang contractor ay may karapatan sa isang patas na pagsasaayos ng oras ng pagkukumpleto o presyo ng kontrata para sa suspensyon ng trabaho dahil sa mga nabanggit na pangyayari. Article number 27. Owner right to suspend the work. Suspension without cause. The owner may at any time and without cause suspend the work of any portion hereof for a period of not more than the aggregate period of 15 days by notice in writing to contractor and shall fix the date on which work shall be resumed. So, the contractor shall resume the work on the date so fixed. The contractor will 42 be allowed an adjustment in the contract price to include demobilization and remobilization costs or standby time as applicable, as well as adjustment of completion time which shall not be less than the period of suspension and shall include the delay due to remobilization of equipment and personnel. The owner may not suspend the work without just cause for more than an aggregate period of 15 days without the contractor's consent. So, sa article din ito is sakop din yung just causes for suspension of work. So, just causes for suspension of work. The owner, by a written order, may direct the contractor to stop the work or any portion thereof. So, in any of the following cases, until the cause of such order has been eliminated, so unsuitable weather or other condition considered unfavorable for a prosecution of the work. Next is the failure of the contractor to correct condition which constitute a danger to his worker or the general public or to correct the defective work. Next is the failure of contractor na maisagawa ng wasto yung order na inisyo ng may-ari or sumunod sa anumang provision ng kontrata o yung paulit-ulit na pag-fail niya na isagawa yung mga ordinance with a contract. Article number 28. Owner's right to terminate contract. Termination with a cause. The owner may immediately terminate the contract without prior notice to the contractors. So, for example, if the contractors is a judge, bankrupt, or insolvent, or if a contractor makes a general assignment of his asset for a benefit of his creditors. Next is other ground for termination with cause. So the owner may terminate the contract upon the is when the contractors repeatedly fails to supply based on the construction schedules the sufficient number of skilled workmen or suitable materials or equipment. Also, if the contractors repeatedly fails to make without just cause prompt payments to subcontractors for labors, materials or equipments, and the completion of works is being delayed. Termination without cause. Upon 50 days written notice to the contractors, the owner may, without prejudice to any other right or remedy, elect to abandon the work and terminate the contract. In such case, the contractor shall be paid for all work executed and any expenses. Article number 29. Owner's right to proceed with the work after reduction in contractor's scope of work. Partial takeover from the contractor. So, owner's right to carry out the work. So, na mangyayari to if the contractor is paulit-ulit na mag-fail to supply the sufficient skilled workmen or suitable materials or equipment. Also, if paulit-ulit siya na mag-fail to make prompt payment to subcontractors for labor, materials, or equipment. So, the owners may, after 7 days following receipt by contractor of written notice without prejudice to any other remedy, the owner may have and without term. Dito sa article number 29 is nakapaloob din dito yung use of materials and equipment at site, owner to complete work, evaluation cost of work. Sa use of materials and equipment at site, yung contractor, upon receiving notice of termination, shall vacate the site and deliver possession of the work. Lahat ng mga materyales, halaman, gamit sa bahay, at iba pang mahahalaga na maaaring kailangan para sa pagtayo ng project ay mananatili sa site hanggang sa makumpleto ang trabaho, and credit the constructor a reasonable rental for the use of the same. So, for the owners to complete work naman is, dito naman is sinasabi na yung owner shall then take over the use and such tools, appliances, and materials of every description na matatagpuan sa site para sa hangaring makumpleto ang trabaho. So, for evaluation of cost of work, dito naman, pag termination ng contract, ay aalamin ng owner at aayusin ang halaga ng gawaing nakumpleto ng contractor at hindi babayaran ng owner ang lahat ng mga nagamit na material ng contractor na kinuha sa may-ari sa oras ng nasabing terminator. So, in case of the suspension of works, so lahat ng mga di nabayaran na trabaho or yung mga natapos na trabaho ay babayaran ng owner. So, dito naman sa liquidated damages, kung saan ang contractor ay tumanggi or nabigo to satisfactory complete the work sa loob ng tinakdang oras ng kontrata, babayaran ng contractor sa owner ang mga liquidated damages in the amount of stipulated. Next is to entitled to such liquidated damages, the owner does not have to prove that it has incurred actual damages. So however, sa anumang kaso, hindi dapat lumagpas sa 10% ng kabuuang presyo ng contract ang kabuuang halaga. If before the completion of the whole of the work, any part or section of the work has been certified by the owner's engineer or representative as completed and occupied or used by the owner.
Section 4. Joint and Solidary Obligations. Article 1207. The occurrence of half or more creditors or more debtors in one and the same obligation does not imply that each one of the former has a right to demand, or that each one of the latter is bound to render entire compliance with the prestation. There is solidary liability only when the obligation expressly so states, or when the law or the nature of the obligation requires solidarity. So, this Article 1207, obviously, this talks about joint and solidary obligation, meaning a obligation according to plurality of subjects, meron tayong single or individual obligation. Dito, iisa lang yung debtor at isa lang din si creditor o yung umutang at nagpapautang. And collective obligation wherein there are two or more debtors or two or more creditors. So, ano nga ba yung joint obligations and solidary obligations? Kapag joint, guys, example nito is to each his own sila. Kung ano lang yung share or kung ano lang yung part niya, yun lang yung obligasyon niya. Kapag solidary obligation naman dito, simple lang. Ano siya, one for all and all for one sila. At ang sabi dito, there is solidary liability only when the obligation expressly so states or when the law or the nature of obligation requires solidarity. Na sabi, magkakaroon lang daw ng solidary liability if when the obligation expressly so states or when the law or the nature of the obligation requires solidarity. Section 5. Divisible and indivisible obligations. Article 1223. The divisibility or indivisibility of things that are the object of obligation in which there is only one debtor and only one creditor does not alter or modify the provision of Chapter 2 of this title. So this provision talks about divisibility or indivisibility of the things that are the object of obligation. So, ano nga ba ang ibig sabihin ng divisible and indivisible obligations? Kapag divisible obligation, kapag siya ay capable of partial fulfillment. Halimbawa na nito is to deliver 200 kilos of sugar. And indivisible obligation naman ay kapag hindi siya capable of partial fulfillment. Halimbawa ay to deliver a specific car. Section 6. Obligation with a penal clause. Article 1226. In obligation with a penal clause. So ano muna ang ibig sabihin ng penal clause? A penal clause is a accessory undertaking attached to an obligation to assume greater liability on the part of the obligor in case of breach of obligation. O meaning, sa obligation may penal clause, merong accessory undertaking which is a penalty that will substitute the indemnity for damages and payment of interest kung sakaling may magkaroon ng non-compliance ng obligation. The penalty shall substitute the indemnity for damages and the payment of interest in case of non-compliance. If there is no stipulation in the contrary, nevertheless, damages shall be paid if the obligor refuses to pay the penalty or is guilty of fraud in the fulfillment of the obligation. So, meron siyang exceptions. First is no stipulation, and second is pag may refusal ng debtor to pay the penalty. And yung third is si debtor ay guilty of fraud in the fulfillment of obligation. At sabi dito, yung penalty, yung stipulation in a contract is demandable only kapag merong breach of the obligation. And that is provided rin na yun, penal clause is not contrary to law, moral, good custom, and public order. And next is Chapter 4, Extinguishment of Obligations. So dito, in Article 1231, meron siyang 6 na sections, which is papaliwanag ko na lang siya ng maikli kasi napakahaba niya. So dito, pinapakita lang sa bawat isa kung paano ma-extinguish yung obligation. So first is by payment or performance. Or money means not only the delivery of money but also performance. And the second is from the first scenario in Article 1262, an obligation consists in the delivery of a determinate thing shall be extinguished if it should be lost or destroyed without the fault of the debtor and before he has incurred in delay. Next is by the condonation or remission of the debt. From Article 1270, condonation or remission is essentially gratuitous and requires the acceptance by obligor. It may be made expressly or impliedly. Next is by the confusion or merger of the rights of creditor and debtor. The obligation ay may extinguish from the time the characters of creditor and debtor are merged in the same person. Next is by compensation. In Article 1272, 78 pala, the compensation shall take place when two persons in their own rights are creditors and debtors of each other. Next is by innovation. So, sa innovation, meron siyang tatlong modified. First is changing their object or principal conditions. First, substituting the person of the debtor. And last, or third, subrogating the third person in the rights of the creditor. So, from Article 1291, so obviously this provision talks about novation. First is by changing the object or principal condition mismo ng obligation. Next is sa pag-change naman ng person of debtor. And third is sa pag-change naman ng person sa creditor. Contracts. Chapter 1, General Provisions. Article 1305. A contract is a meeting of minds between two persons whereby one by himself with respect to the other to give something or to render some service. So, this provision gives the meaning of the contract or kontrata na magbibigay din ng meaning about meeting of two minds between two contracting person, which takes place when an offer by one person is accepted by the other person. Sample na rin nito is yung mga pangkaraniwan ng ginagawa natin sa araw-araw, such as kapag bibili tayo sa tindahan, may kontrata na rin na nangyayari doon. At example na rin is kapag may usapan kayo ng kaibigan mo, may hiniram ka na ganito, ganyan. At saka usually ang contract ay entered by two person. So dito pwede rin higit lang dalawang person, pwede ring tatlo, apat, at possible din kapag one person kapag may kontrata ka sa sarili mo.
Chapter 2, Essential Requisites of Contracts. General Provisions, Article 1318, sabi dito sa pagkakaroon ng isang kasunduan, kinakailangan na ito ay naglalaman ng mga sumusunod. So una, ang dalawang partido ay lubos na nagkakaintindihan. Pangalawa, dapat sigurado yung both parties sa pinagkakasunduan nila. And last, dapat yung cause ng obligation ay malino na nabuo para sa kinakailangan pagsunod sa kasunduan ng dalawang partido. Section 1, Consent. Article 1319, sabi dito ang pagsang-ayon ay maihahayag kapag nagkasundo ang bawat partido at tinanggap na yung mga bagay na magiging paksa ng kasunduan. So ang pag-aalok ay dapat naaayon sa kontrata. Article 1320, an acceptance may be expressed or implied. Ang pagtanggap ay maaaring ipahayag o ipinahiwatig. Article 1321, the person making the offer may fix the time, place, and manner or acceptance, all which must be complied with. So the offer to set forth the terms of acceptance. When these terms are set forth, the offeree, should he wish to accept, must comply with the terms of the offeror. Article 1322, an offer made through an agent is accepted from the time acceptance is communicated to him. So sabi dito, ang offer na ginawa gamit ang ahente ay nangangahulugang tanggap na sa oras na ang pagtanggap ay pinabatid na sa agent. Article 1323, an offer becomes ineffective upon the death, civil interdiction, insanity, or insolvency of either party before acceptance is conveyed. So sabi sa Article 1323, ang offer ay mawawalan ng bisa o ng saysay sa pagkamatay, pagbabawal na sibil, pagkasira ng pag-iisip, kawalan ng ibabayad ng partido bago pa man niya tanggapin ang offer. Article 1324, kapag ang nag-o-offer ay ginusto na bigyan ng oras ang inaalok para tanggapin ang offer, yung nasabing offer ay pwedeng iurong anytime bago ito tanggapin sa pamamagitan ng pagbibigay alam, depende na lang kung ang option ay nakabase sa halaga na pwedeng pera o pangako. Article 1325, unless it appears otherwise, business advertisements of things for sale are not definite offers, but mere invitations to make an offer. Ibig sabihin ng definite offer, it does not contain all the specific particulars needed in a contract. Article 1326, advertisements for bidders are simply invitations to make proposals, and the advertiser is not bound to accept the highest or lowest bidder unless the contrary appears. Most advertisements are simply invitations to make an offer and are not offers in themselves, since not all the necessary terms can fit in the advertisement. Article 1327, ibig sabihin lang nito ay hindi pwedeng bigay ng consent o ng pagpayag sa isang kontrata yung mga 18 below ang age, saka yung mga taong mayroong sakit sa pag-iisip at yung mga deaf mutes na hindi marunong magsulat. Article 1328, sabi dito yung mga contracts na ginawa habang nasa tamang pag-iisip ay valid, while yung mga contracts naman na sinang-ayunan habang nasa kalasingan or under a hypnotic spell ay pwedeng ipawalang bisa. Article 1329, sabi dito, ang kawalang kakayahan na nakalagay sa Article 1327 ay sumasailalim sa pagpabagong naaayon sa batas at naiintindihang hindi makakasama sa espesyal na mga diskwalipikasyong tinatag ng mga batas. Article 1330, a contract where consent is given through mistake, violence, intimidation, undue influence, or fraud is voidable. Kapag ang pagpayag sa kasunduan na may kalakip na pagkakamali, intimidasyon, pamamersa, panloloko at inararapat na impluwensya, yung contract ay pwedeng ipawalang bisa. Article 1331, in order that mistake may invalidate consent, it should refer to the substance of the thing which is the object of the contract, or to those conditions with the principally move on or both parties to enter into the contract. Article 1332, sabi dito kapag isa sa mga partido ay hindi marunong bumasa o ang kontrata ay nakasulat sa language na hindi nito naiintindihan at may pagkakamali o inakusahan ng panloloko ang taong nagpapatupad ng kontrata, ay dapat ipakita na yung mga nakalagay doon ay naipaliwanag ng maayos sa taong unang nabanggit. Article 1333, there is no mistake if the party alleging it knew the doubt, contingency of risk affecting the object of the contract. Article 1334, mutual error as to the legal effect of an agreement when the real purpose of the parties is frustrated may vitiate consent. Article 1335, There is violence when in order to wrest consent, serious or irresistible force is employed. There is intimidation when one of the contracting parties is compelled by a reasonable and well-grounded fear of an imminent and grave evil upon his person or property, or upon the person or property of his spouse, descendants, or ascendants to give his consent. To determine the degree of intimidation, the age, sex, and condition of the person shall be borne in mind. A threat to enforce one's claim through competent authority if the claim is just or legal does not vitiate consent. Article 1336. Violence or intimidation shall annul the obligation, although it may have been employed by a third person who did not take part in the contract. Ang karahasan o pananakot ay dapat mawalang misa sa obligasyon, bagamat maaaring ito ay ginawa ng ibang tao na hindi parte ng kontrata. Article 1337, sabi dito mayroong hindi nararapat na impluwensya kapag ang isang tao ay gumawa ng di gustong kalamangan gamit ang kanyang kapangyarihan upang pangibabawan ng kagustuhan ng iba at nagdulot sa huli ng pagkawala ng kanyang makatwirang kakayahang pumili ng malaya. Ang mga sumusunod na sitwasyon ay dapat isaalang-alang. Una, ang confidential, pamilya, espiritual at iba pang mga relasyon sa pagitan ng mga partido o ang katunayan na ang tao di umano'y sobrang naimpluwensyahan ay dumaranas ng kahinaan sa isip o kaya ignorante o kaya naman nasa pinansyal na pagkabalisa. Article 1338, there is fraud when through insidious words or machinations of the contracting parties the other is induced to enter into a contract which without them he would not have agreed to. Article 1339, failure to disclose facts when there is a duty to reveal them as when the parties are bound by confidential relations constitute fraud. So sabi sa Article 1339, pag meron kang duty to reveal facts and you fail to disclose it will consider it as panloloko. Article 1340, ang karaniwang exaggeration sa kalakalan kapag ang isang partido ay may pagkakataon na malaman ng katotohanan ay hindi makukonsider na panlilinlang. Article 1341, a mere expression of an opinion does not signify fraud unless made by an expert and the other party has relied on the former's special knowledge. Article 1342, misrepresentation by a third person does not vitiate consent unless such misrepresentation has created substantial mistake and the same as mutual. Article 1343, misrepresentation made in good faith is not fraudulent but may constitute error. Ang pagsisinungaling na hindi naman sinasadya ay hindi panloloko pero pwedeng magkaroon ng kamalian. Article 1344, sabi dito, para ang pandaraya ay magawang ipawalang bisa ang isang kasunduan, dapat ito ay seryoso at hindi dapat ginawa ng parehong partido. Article 1345, simulation of a contract may be absolute or relative. The former takes place when the parties do not intend to be bound at all. The latter when the parties conceal their true agreement. Article 1346. In Article 1346, it says that ang gawa-gawa o katang-isip lamang na kontrata ay walang bisa. Ang medyo gawa-gawa kapag hindi nito naapektuhan ng karapatan ng ibang tao at ang dahilan ng paggawa ay hindi salungat sa batas, moralidad, mabuting kaugalian, pampublikong kaayusan at pampublikong patakaran ay binibigis ng ang mga partido sa kanilang tunay na pagkasunduan. Section 2, Object of Contracts, Article 1347, all things which are not outside the commerce of men, including future things, may be the object of a contract. All rights which are not intransmissible may also be the object of contracts. Article 1348, impossible things or services cannot be the object of contracts. Article 1349, the object of every contract must be determinate as to its kind. The fact that the quantity is not determinate shall not be an obstacle to the existence of the contract, provided it is possible to determinate the same without the need of a new contract between the parties. Section 3, Cause of Contracts. Article 1350, sabi dito, ang pagkakautang na kailangan bigyan ng pangunahing pansin ay dapat nauunawaan ng bawat partido, kagaya ng mga bagay na mga pangako ng bawat isa, mga bagay na bayaran at serbisyo at benepisyong gagawin at mga kagalingan at kabutihan na magagawa nito. Article 1351, the particular motives of the parties in entering into a contract are different from the cause thereof. Ang mga partikular na motibo ng mga partido sa pagpasok sa isang kontrata ay iba sa dahilan nito. Article 1352, contracts without cause or with unlawful cause produce no effect whatever. The cause is unlawful if it is contrary to law, morals, good custom, public order, or public policy. Ang kasunduang walang kabayaran or may layunin na labag sa batas ay walang silbi at epekto. Article 1353, ang kontrata na may paghahayag ng walang katotohanang kadahilanan ay walang bisa, kung ito ay hindi mapapatunayan na kasali sa isang kadahilanang totoo at naaayon sa batas. Article 1354, although the cause is not stated in the contract, it is presumed that it exists and is lawful unless the debtor proves the contrary. Kahit na ang dahilan na hindi nakasaad sa kontrata, ito ay may tuturing na mayroon at alinsunod sa batas maliban na lang kung ang nagkakautang ay mapapatunayan ng kabaliktaran. Article 1355, except in cases specified by law, lesion and inadequacy of cause shall not invalidate the contract unless there has been fraud, mistake, or undue influence. Chapter 3, Form of Contracts. Article 1356, contracts shall be obligatory in whatever form they may have been entered into, provided all the essential requisites for their validity are present. However, when the law requires that the contract be in some form in order that it may valid or enforceable, or that the contract be proved in a certain way, that requirement is absolute and indispensable. In such cases, the right of the parties stated in the following article cannot be exercised. Article 1357, kung hinihingi ng batas ang isang dokumento ay iba pang special form na tulad ng gawa at mga kontratang nabanggit sa mga sumusunod na article, ang nakikipagkontratang partido ay maaaring pilitin ng bawat isa na sundin ang itsura hanggang sa mabuo ang kontrata. Ang karapatan na ito ay maaaring gawin ng tuloy-tuloy na may pagkilos sa kontrata. Article 1358, Chapter 4, Reformation of Instruments. Article 1359, when there having been a meeting of the minds of the parties to contract, their true intention is not expressed in the instrument purporting to somebody the agreement. By reason of mistake, fraud, inequitable conduct, or accident, one of parties may ask for the reformation of the instrument to the end that such true intention may be expressed. In Article 1360, ang panuntunan sa usaping pangbatas para sa reformasyon ng mga instrumento ay pinatotohanan na tinanggap na kung saan hindi magkakaroon ng problema sa provision ng code. Article 1361, sabi dito kapag may pagkakamali ang bawat isang partido na nagdulot sa kabiguan ng instrumentong ipaalam ang tunay na kasunduan, ang nabanggit na instrumento ay maaaring baguhin. Article 1362, kung isa sa mga partido ay nagkamali at ang isa ay nandaya o umakto ng hindi makatarungan kaya't hindi na ipapakita sa instrumento ang tunay nilang intensyon, pwedeng hingin ng nagkamali na ayusin ng instrumento. Article 1363, when one party was mistaken and the other knew or believed that the instrument did not state the real agreement but concealed the fact from the former, the instrument may be reformed. Article 1364, when through the ignorance, lack of skill, negligence, or bad faith on the part of the person drafting the instrument or of the clerk or typist, the instrument does not express the true intention of the parties, the courts may order that the instrument be reformed. In Article 1365, kung ang dalawang partido ay nagkasundo tungkol sa sangla o pangako ng tunay o personal na pag-aari, ngunit ipinapahayag na instrumento ng pag-aari ay tuwirang na ibenta o mayroong karapatan na bilhin itong muli, ang pagbabago ng instrumento ay tama. Article 1366, there shall be no reformation in the following cases. Una, simple donations inter vivos wherein no condition is imposed. Pangalawa, yung wills. And third, when the real agreement is void. Article 1367, sabi dito kapag ang isang partido ay gumawa ng hakbang para ipatupad ang instrumento o kasulatang napagkasunduan, hindi na pwedeng hilingin ng pagbabago ng mga nakalagay dito. Article 1368, reformation may be ordered at the instance of either party or his successors in interest, if the mistake was mutual, otherwise upon petition of the injured party or his heirs and assigns. Article 1369, the procedure for the reformation of instruments shall be governed by rules of court to be promulgated by the Supreme Court. Ang pamamaraan ng pagre-reforma sa mga instrumento ay pamumunuan ng mga patakaran ng korte na ipapalaganap ng Supreme Court. Chapter 5, Interpretation of Contracts. Article 1370, kapag ang mga napagkasunduan sa kontrata ay malinaw at hindi nang iiwan ng pagdududa sa intensyon ng mga partido, ang literal na ibig sabihin ng mga napagkasunduan ang masusunod. Article 1371, in order to judge the intention of the contracting parties, their contemporaneous and subsequent acts shall be principally considered. Article 1372, however general the terms of a contract may be, they shall not be understood to comprehend things that are distinct and cases that are different from those upon which the parties intended to agree. Article 1373, kung ang kasunduan ay mayroong kahulugan maliban sa isa, ang kahulugan na magbibigay silbi dito ang masusunod. Article 1374, the various stipulations of a contract shall be interpreted together, attributing to the doubtful ones that sense which may result from all of them taken jointly. Article 1375, ang mga salitang may iba't ibang pakahulugan ay uunawain sa paraan na kung saan pinakamalapit sa pinagmulan at bagay ng kontrata. Next is Article 1376, ang dating kinasanayan o kinaugalian ng lugar ay maaaring gamitin sa pagbibigay kahulugan sa mga hindi malinaw sa kontrata at papalitan nito ang mga naalis sa kasunduan ng napagkasunduan. Article 1377, ang interpretasyon ng mga malabong salita o nakalagay sa kontrata ay hindi papaboran ang partido na responsable sa kalabuan nito. Article 1378, when it is absolutely impossible to settle doubts by the rules established in the preceding articles, and the doubts refer to incidental circumstances gratuitous contract, the least transmission of rights and interest shall prevail. If contract is one rus, the doubt shall be settled in favor of the greatest reciprocity of interest. Article 1379, ang mga principles na interpretasyon na nakalagay sa Rule 123 ng Rules of Court ay dapat ding sundin sa paggawa ng mga kasunduan. Chapter 6, Rescissible Contracts. Article 1380, contracts validly agreed upon may be rescinded in the cases established by law. Ang pagpapawalang bisa sa isang wastong kasunduan ay maaari lamang gawin sa mga kasong naaayon sa batas. Article 1381. Article 1382, payments made in a state of insolvency for obligations to whose fulfillment the debtor could not be compelled at the time they were affected are also rescissible. Article 1383, ang pagpapawalang bisa ay nakakatulong. Hindi ito magagamit maliban kung ang panig na nagtitis ng danyos ay walang ibang makabatas na pamaraan na makakuha ng kabayaran o kapalit nito. Article 1384, rescissions shall be only to the extent necessary to cover the damages caused. Article 1385. Article 1386, sabi dito ang pagbawi na tinutukoy sa numbers 1 at 2 ng Article 1381 ay hindi magaganap sa mga kasunduang inaprubahan ng hukuman. Article 1387. Article 1388. Article 1389, the action to claim rescission must be commenced within 4 years. So in Article 1389, ang pagsasagawa sa pagwawalang bisa ay dapat gawin sa loob ng 4 na taon. Para sa mga taong nasa pangangalaga pa, ang panahon na 4 na taon ay magsisimula hanggang sa terminasyon ng taong nabanggit sa kanyang kawalan ng kakayahan. Chapter 7, Voidable Contracts. Article 1390, the following contracts are voidable or annulable even though may have been no damage to the contracting parties. Una, those where one of the parties is incapable of giving consent. Pangalawa, those where the consent is vitiated by mistake, violence, intimidation, undue influence, or fraud. These contracts are binding unless they are annulled by a proper action in court. They are susceptible of ratification. Article 1391. The action for annulment shall be brought within 4 years. This period shall begin in cases of intimidation, violence, or undue influence from the time that the effect of the consent ceases, in cases of mistakes or fraud from the time of the discovery of the same, and when the action refers to contracts entered into by minors or other incapacitated person from the time the guardianship ceases. Article 1393. Sabi sa Article 1393, ang ratifikasyon ay maaaring maipakita ng hayag o hindi. Malinaw na mayroong di hayag na ratifikasyon kung nababatid niya ang dahilan kung bakit ang kasunduan ay maipawawalang bisa at ang dahilang iyon ay hindi na umiiral. Ang tao na may karapatang mag-apila ay maghahain ng aksyon na nagpapahiwatig ng kanyang intensyon talikdan ng kanyang karapatan. Article 1394. Ang mga nangangalaga sa mga taong walang legal na kapasidad ay maaaring magpatibay ng kontrata na ginawa ng kanilang alaga. Article 1395, sabi dito, ang pagpapatibay ay hindi kailangang humingi ng pagsang-ayon ng nagkasundong partido na walang karapatan na magdala ng aksyon sa pagsasawalang bisa. Article 1396, ratification cleanses the contract from all its defects from the moment it was constituted. Ang pag-aproba ay nililinis ang kontrata mula sa lahat ng depekto simula sa oras na ito ay sinagawa. Article 1397, the action for the annulment of contracts may be instituted by all who are thereby obliged, principally or subsidiarily. However, persons who are capable cannot allege the incapacity of those with whom they contracted, nor can those who exerted intimidation, violence, or undue influence, or employed fraud, or caused mistake base their action upon these flaws of the contracts. Article 1398, kapag naipaiwalang bisa na ang mga partidong nagkasundo ay maaaring magbalik ng mga bagay na sumailalim sa kanilang kasunduan noong may bisa pa ang kontrata. Ang mga bunga nito at ang mga halaga ng mga interes maliban sa mga kaso na labag sa batas. Sa mga obligasyong serbisyo, ang pinagkasunduan ang mga halaga ng danyos perwisyo ang magiging batayan ng mga pinsala nito. Article 1399. Sabi dito, kung ang depekto ng kontrata ay naglalaman ng kawalan ng kapasidad ng isang partido, ang may kapansanan ng tao ay hindi kinakailangang gumawa ng kung anumang restitusyon maliban sa napakinabangang bagay o premyo na tanggap niya. Article 1400. Whenever the person obliged by the decree of annulment to return the thing cannot do so because it has been lost through his fault, he shall return the fruits received and the value of the thing at the time of the loss, with interest from the same date. Article 1401. Ang pagpawalang bisa ng kontrata ay maaaring mawala kung ang taong nagpapawalang bisa ay may pagkakamali na nagresulta sa pagkawala o pagkasira ng bagay na tinutukoy sa kasunduan. Gayun din kung ang karapatan ay batay sa kawalan ng kapasidad ng isang tao kung siya mismo ang nagdulot ng pagkawala ng nasabing bagay. Article 1402, sabi dito hanggat isa sa mga partido ay hindi pa binabalik ang kanyang responsibilidad na ibalik, ang kabilang partido ay hindi pwedeng piliting gawin ang nakatoka niyang gawin. Chapter 8, Unenforceable Contracts. Article 1403, Article 1404, unauthorized contracts are governed by Article 1317 and the principles of agency in the Title X of this book. Article 1405, ang mga kontratang lumalabag sa batas ng Statute of Frauds na tinutukoy sa number 2 of Article 1403 ay pinagtibay ng kabiguan ng pagtutol sa presentasyon ng pananalitang ebidensya upang patunayan ng pandaraya o dahil sa pagtanggap ng mga kapaki-pakinabang sa ilalim nito. Article 1406, when a contract is enforceable under the Statute of Frauds and a public document is necessary for its registration in the Registry of Deeds, the parties may avail themselves of the right under Article 1357. Article 1407, in a contract where both parties are incapable of giving consent, express or implied ratification by the parent or guardian, as the case may be, of one of the contracting parties shall give the contract the same effect as if only one of them were incapacitated. Article 1408, ibig sabihin nito ang pagkawalang epekto ng kontrata ay hindi maaaring batikusin ng ibang tao na hindi kasama sa kontrata. Chapter 9, Void or Inexistent Contracts. Article 1409, Article 1410, the action or defense for the declaration of the existence of a contract does not prescribe. Ang aksyon at depensa para ideklara ang kawalan ng kontrata ay hindi iuutos o ihahatol. Article 1411, when the nullity proceeds from the illegality of the cause or object of the contract and the act constitute a criminal offense, both parties being in pari delicto, they shall have no action against each other, and both shall be prosecuted. Moreover, the provisions of the Penal Code relative to the disposal of effects or instruments of a crime shall be applicable to the things or the price of the contract. Article 1412. Article 1413, ibig sabihin lang nito ang interest na binayaran na kung saan humigit pa sa interest na pinahihintulutan ng usury loss ay maaaring maibalik sa nangutang, kasama ang interest simula sa araw na kung saan binayaran niya ito. Article 1414, when the money is paid or property delivered for an illegal purpose, the contract may be repudiated by one of the parties before the purpose has been accomplished or before any damage has been caused to a third person. In such case, the courts may, if the public interest will thus be subserved, allow the party repudiating the contract to recover the money or property. Article 1415, kung ang isang panig sa kasunduan ay walang kapasidad na magbigay ng pamamayagan, ang mga hukom ay maaaring mamayagan sa pagbalik ng binayad o sa mga ari-ari ang naibigay nito sa ngalan ng hustisya. Article 1416. Article 1417, sabi dito kapag ang presyo ng anumang bilihin o produkto ay tinalaga ng batas o sa kapangyarihan ng batas, ang sino man na nagbayad ng sobra ay maaaring bawiin ng kalabisan. Next is Article 1418. Kung aayusin ng batas o pahihintulutan nito ang paglaan ng pinakamataas na bilang ng oras ng pagtatrabaho, ang kawani ay maaaring humingi ng karagdagang kabayaran sa labis na oras ng serbisyong kanyang inilaan. Article 1419. When the law sets or authorizes the setting of a minimum wage for laborers and a contract is agreed upon by which a laborer accepts a lower wage, he shall be entitled to recover the deficiency. Article 1420. In case of divisible contract, if the legal terms can be separated from the legal ones, the latter may be enforced. Sa mga kaso na maaaring hatiin ng kontrata, kung ang illegal na mga bahagi nito ay maaaring hiwalay sa mga legal na bahagi, ito ay papatupad. Article 1421, sabi dito ang depensang illegal na kasunduan ay hindi magagamit ng ibang tao na ang mga interes ay hindi direktang naapektuhan nito. Article 1422, a contract which is the direct result of a previous illegal contract is also void and inexistent. Ang isang kasunduan na bunga lamang ng isang naunang kasunduan na illegal ay siya ring walang bisa. Natural obligations. Article 1423, obligations are civil or natural. Civil obligations give a right of action to compel their performance. Natural obligations, not being based on positive law but on equity and natural law, do not grant a right of action to enforce their performance, but after voluntary fulfillment by the obligator, they authorize the retention of what has been delivered or rendered by reason thereof. Some natural obligations are set forth in the following articles. Article 1424, kapag ang karapatan na maghain ng reklamo sa isang obligasyon sibil ay natapos na sa pamamagitan ng extensive prescription, ang may pananagutan na kusang isinagawa ang kontrata ay hindi na maaaring bawiin ang naibigay o halaga ng serbisyong ginawa. Article 1425, when without the knowledge or against the will of the debtor, a third person pays a debt which the obliger is not legally bound to pay because the action thereon has prescribed, but the debtor later voluntarily reimburses the third person, the obliger cannot recover what he has paid. Article 1426, ibig sabihin lang nito kung isang menor de edad na nasa 18 to 21 years old na pumasok sa isang kontrata nang walang pahintulot ng mga magulang o ng guardian, pagkatapos voluntaryong maipasa walang bisa ang kontrata at ibinalik ang kung anumang natanggap, sa kabila ng hindi pagtanggap ng anumang benepisyo mula sa kontrata ay walang karapatang magdemanda na ibalik ang kanyang binalik. Article 1427, Article 1428, Article 1429, sabi dito kung ang tagapagmana ay nagbayad ng pagkakautang ng kanyang pinagmanahan na higit pa sa kanyang minana, ang kabayaran ay wasto at hindi niya maaaring ipawalang bisa. Article 1430, when a will is declared void because it has not been executed in accordance with the formalities required by law, but one of the intestate heirs, after the settlement of the debts of the deceased, pays a legacy in compliance with the clause in the defective will, the payment is effective and irrevocable.
Let's proceed to Section 9, Responsibilities and Liabilities of the Contractor, the Owner. Article 30, Contractor's Responsibility for Accidents and Damages. 30.01, Safeguards to be undertaken by the contractor. The contractor shall all shall take all necessary precautions for the safety of employees and workmen on the work and comply with all laws to prevent injury to persons on, about, or adjacent to the premises where the work is being performed. The contractor shall erect and properly maintain at all times, as required by the conditions and progress of the work, such barriers, shoring, supports, braces, lights, danger signs, and necessary safeguards as will protect workmen and the public, and as will effectively prevent any injury to the contractor. Shall designated responsibility members of his organization at the site, whose duty shall be prevention of accidents and damages to the work, the owner's property and adjoining property, the name and the position of the person so designated shall be reported by the contractor in writing to the owner. The contractor shall be primarily responsible for all safety measures and prosecuting the work in accordance with the safety manual approved by the Construction Industry Authority of the Philippines. Second, owner not to be responsible. The contractor shall render the owner free and harmless for the death of the disease contracted or injury received by the contractor or any of his employees or laborers, for any damage that by or to contractor's plant or materials from the any source or cause, and for damages caused by the contractor or his employees to any property of the owner and adjoining property. Contractor's default. The owner shall have the right to undertake reasonable safety and protection measures in case of contractor's default and charge the cost of such measures to the contractor. Article 31, Contractor's Insurance and Bonds. Contractor's Liability Insurance. The contractor shall secure and maintain insurance coverage from the insurance company acceptable to the owner, as will protect himself, his subcontractors, and the owner from the claims for bodily injury, death, or property damage which may arise from work under the contract. Accident Insurance for Workers. The contractor shall, in addition to compulsory coverage of workers, undertake the Workmen's Compensation Law, obtain insurance coverage for accidental death or injury of his officers, employees, and laborers without regard to their tenure or employment as permanent or regular workers, project workers, or casual employees performing work at the project site in an amount of not less than 100,000 pesos per officer, employee, or laborer. The premiums to be paid on the insurance policy shall be paid by the contractor and without cost to those covered by the policy. Contractor's par insurance. In addition to such par insurance as the contractor elects to carry for his work, he shall secure and maintain the policies upon such structures and materials in such amounts as shall be designated in the joint names of the contractor and the owner as the respective interests may appear. This policy shall be secured from a company which is satisfactory to the owner and delivered to the owner. Article 32, Owner's Responsibilities and Liabilities. Advance payment. An advance payment is an amount to be mutually agreed upon shall be paid by the owner to the contractor, provided that the contractor shall post a surety bond of equivalent amount callable on demand and acceptable to the owners to guarantee its repayment. The contractor shall use this advance payment for mobilization, purchase of materials, and the like for the project. This shall be recouped pro rata in progress billings. Protection of employees and professional performing services for the owner. The owner shall be responsible for the and shall maintain such insurance as will protect him from liability for personal injury, including disease and death of persons under his employ or service, whether as temporary or permanent in status, that are assigned to the project. Owner's optional insurance. The owner may maintain such insurance as which will protect him from his contingent liability for damages for personal injury, including death, which may arise from the work under the contract. Article 33, Liens, Disputes, and Arbitration. Liens as a condition to final payment and or the release of the retention. The contractor shall release the work from any illegal liens attaching therewith as a result of unpaid claims of subcontractors and or suppliers for the supply of materials and or equipment to the contractor for the project in the form of a sworn statement by the contractor or a duly authorized officer of the contractor stating that all such claims have been fully paid and furnishing the owner when required with a receipt or acknowledgement of payments issued by the subcontractors and or suppliers. Should any of such claims remain unpaid as the time of executing the sworn statement, or if the contractor is unavailable to furnish the owner with proof of full payment to any subcontractor or supplier, the contractor shall furnish the owner with an indemnity bond equal to the amount of the claims still unpaid. The indemnity bond may be issued by the surety which previously issued the contractor's performance bond or any other bond required under the contract, or by any other surety acceptable 52 to the owner. The owner may recover against the contractor and or the surety on the latter's indemnity bond in any amount paid by the owner to discharge such liens, including costs incurred incident thereto and reasonable amount of attorney's fees. Section 10, Owner's Representative. The owner's Article 34, the owner's representative shall either be an architect, the engineer, construction manager, or other person designated by the owner as the owner's representative. The owner's representative shall have the full authority to act for and on behalf of the owner in all matters which under the contract the owner shall give his consent, approval, or decision. The owner shall give the contractor at the time of the notice to proceed or any time thereafter the notice of appointment of the owner's representative unless the contractor is notified in writing by the owner of the limits of the authority of the owner's representative. It shall be understood that the authority of the latter to act and on behalf of the owner is full and unqualified. In the absence of a written communication by the owner to the contractor notifying the latter of the designation of a particular persons as the owner's representative, the architect shall perform the functions and have the authority of the owner's representative. The project or work involves the construction of a building, but if the project or work involves in the construction of an engineering structure other than a building or the construction of a building, if such constitutes only a minor portion of the project, the engineer shall perform the functions and have the authority of an owner's representative. The owner's representative shall also perform the functions of construction manager unless the owner designates another person as a construction manager. If the owner shall designate a construction manager and define his functions, those functions of a construction manager not delegated to the latter shall be performed the owner's representative. Section 11, Schedule of Time Limits. The contractor shall perform his work subject to certain time limits. This index section is as base as the entire general conditions is provided for in order to facilitate the execution of this work. Directly shown in the table, the leftmost corner number and title at the middle time limit, and of the right corner reference article number. Extracts from the new Civil Code on Obligations and Contracts. Title 1, Obligations, Chapter 1, General Provisions. Article 1156, an obligation is juridical necessity to give, to do, or not to do. Article 1157, obligations arise from law, contracts, quasi-contracts, acts or omissions punished by law, and quasi-delicts. Article 1158, obligations derived from law are not presumed, only those expressly determined in the code or special laws are demandable and shall be regulated by the precepts of the law which establishes them, and as to what has not been foreseen by the provision of this book. Article 1159, obligations arising from the contracts have the force of law between contracting parties and shall comply within good faith. Article 1160, obligations derived from quasi-contract shall be subject to the provisions of Chapter 1, Title 17, Extra Contractual Obligations. Article 1161, civil obligations arising from the criminal offenses shall be governed the penal laws subject to the provisions of Article 2177 and the pertinent provisions of Chapter 2 Preliminary Title on Human Relations and Title 17 Damages Regulating Damage. 18 regulating damage. Article 1162, obligations derived from quasi-delicts shall be governed by the provision of Chapter 2 Title 17 of this book and by special laws. Chapter 2, Nature and Effects of the Obligation. Article 1163, every person obliged to give something is also obliged to take care of it with the proper diligence of a good father of a family, unless the law or the stipulation of the parties requires another standard of care. Article 1164, the creditor has a right to the fruits of the thing from the time the obligation to deliver it arises. However, he shall acquire no real right over it until the same has been delivered to him. Article 1165, when what is to be delivered, it is determined thing, the creditor, addition to the right granted him by Article 1170, may compel the debtor to make delivery. If the thing is indeterminate or genetic, he may ask the obligation complied with at the expense of the debtor. If the obligor delays or has promised to deliver the same thing to two or more persons who do not have the same interest, he shall be responsible for fortuitous event until he has effected the delivery. Chapter 3, Different Kinds of Obligation. Section 1, Pure and Conditional Obligations. Article 1179, every obligation whose performance does not depend upon the future or uncertain event or upon a past event unknown to the parties is demandable at once. Article 1180, when the debtor binds himself to pay when his men permit him do so, the obligation shall be seen to be one with a period subject to the provisions of Article 1197, Article 1181, and conditional obligations, the acquisition of rights as well as the extinguishment or loss of those already acquired shall depend upon the happening of those events which constitute the condition. Section 2, Obligation with a period. Article 1193, obligation for whose fulfillment a day certain has been fixed be demandable only when that day comes. Obligation with a result, the period take effect at once but terminate upon the day certain. A day certain is understood to be that which must necessarily come, though it may not be known when. Article 1194, in case of loss, deterioration, or improvement of the thing before arrival of the day certain, the rules in Article 1189 shall be observed. Article 1195, anything paid or delivered before the arrival of the period, the being unaware of the period or believing that the obligation has become due and demandable may be recovered with the fruits and interest. Article 1196, whenever in an obligation a period is designated, it is presumed have been established for the benefit of both the creditor and the debtor, unless named the tenor of the same or other circumstances, it should appear that the period has been established in favor of one of or of the another. Section 3, Alternative Obligations. Article 119, a person alternatively bound by different prestations shall perform one of them. Article 1200, the right of choice belongs to the debtor unless it has been expressly granted to the creditor. Art 1201, the choice shall produce no effect except from the time T has communicated. Article 1200, for the creditor shall have a right to indemnity for damages when through the fault of the debtor all the things which are alternatively the object of the obligations has been lost or the compliance of the obligation has become impossible. The indemnity shall be fixed, taking as a basis the value of the last thing which disappeared or that of the service which last became impossible. Damages other than the value of the last thing or services may also be awarded. Then, proceed tayo sa Title 4 sa Estopel. So, it is consists of Articles 1431 to Article 1449. Para maipaliwanag ko ng maikli, Estopel ay ang prinsipyo na humahadlang sa isang tao na mag-giit or mag-contradict sa isang bagay na salungat sa kung anuman ang naipahiwatig na nila or nakaraang pagkilos o pahayag ng taong iyon o ng isang naunang nauugnay na pagpapasya sa panghukuman. So, under sa Article 1431, an admission or representation is rendered conclusive upon the person making it. In Article 1432, the principles of Estopel are hereby adopted insofar as they are not in conflict with the provisions of this code, the Code of Commerce, the rules of the court, and special laws. Article 1433, Estopel may be in face or by deed. Article 1434, when a person who is not the owner of things sells or alienates and delivers it, and later the seller of the grantor acquires title thereto, such title passes by the operation of law the buyer or the guarantee. So mag-pass forward na tayo dahil ang pinaka ibig sabihin talaga ng Estopel ay to force consistency and not contradicts oneself's argument, statement, or previous claims. Ang sunod ay Title 5 Trust at Chapter 1 General Provisions. So may tatlo lang siya article sa Chapter 1. Una, pinapaliwanag yung trustor, yung trustee, saka yung beneficiary. Sa Article 1441, pinapaliwanag ang dalawang example ng trust. Una, ang express, tas pangalawa ang implied. Tas in Article 1442, the principles of the general law of trust, insofar as they are not in conflict with this code, the Code of Commerce, the rules of the court, and special laws, are hereby adopted. Next chapter is express trust. Express trust, in Article 1443, no express trust concerning an immovable or any interest therein may be proved by the parole evidence. Ang express trust ay trust na kung saan ang nagdesisyon ay ang trustor at hindi ng law. In Article 1444, no particular words are required for the creation of an express trust, it being sufficient that a trust is clearly intended. In Article 1445, no trust shall fail because the trustee appointed declines the designation unless the contrary should appear in the instrument constituting the trust. In Article 1446, the acceptance by the beneficiary is necessary. Nevertheless, if the trust imposes no onerous condition upon the beneficiary, his acceptance shall be presumed, if there is no proof of the contrary. Sunod naman tayo sa Chapter 3 sa implied trust, which is mahaba. About 42 articles. So, kaya ito naging mahaba kasi yung mismong korte ang nagdidesisyon na magbigay ng trust sa isang beneficiary. Tas karaniwan ang trustee ay part ng korte or ng mga tao. Sunod tayo, Title for Sales. Chapter 1, Nature and the Form of the Contract. So this is comprised of Articles 1458 and Article 1488. Kaya mahaba to dahil ipinapaliwanag dito ang mga tinatawag nating mga vendor, mga buyer, purchaser, saka bendi. Hindi maaaring sa Article 1458 nakasaad by the contract of sale, one of the contracting parties obligates himself to transfer the ownership and to deliver a determined thing, and the other to pay therefor a price certain in money or its equivalent. The thing but must be licit, and the vendor must have a right to transfer the ownership thereof at the time is delivered. A thing is determined when it is particularly designed or physically segregated from all other of the same class. In Article 1461, things having a potential existence may be the object of the contract of sale. In Article 1462, the goods which form the subject of a contract of sale may be either existing goods owned or possessed by the seller, or goods to be manufactured, raised, or acquired by the seller after the perfection of the contract of sale. In this title called future goods. In Article 1463, the sole owner of a thing may sell an undivided interest therein. In Article 1464, in the case of a fungible goods, there may be a sale of an undivided share of specific mass through the seller supports to sell the buyer to buy a definite number, weight, or measurement of the goods in the mass, and through the number of the goods in the mass is undetermined. By such a sale, the buyer becomes owner in common of such share of the mass as the number, weight, or measure both bears to the numbers, weight, or measure of the mass. So, tutuloy na tayo dahil mahaba. Tas yung ibang articles nasa PowerPoint man. Chapter 2, Capacity to Buy or Sell. In Article 1489, all persons who are unauthorized in this code to obligate themselves may enter into a contract of sale, saving the modifications contained in the following articles. Where necessaries are those sold and delivered to a minor or other person without capacity to act, he must pay a reasonable price therefor. Necessaries are those referred to in Article 290, 1457. In Article 1490, the husband and the wife cannot sell property to each other except may ilan siyang excluded times kung saan pwede. Thus, Article 1491, the following persons cannot acquire by purchase, even at public or judicial auction, either in person or through the mediation of another. In Article 1492, the prohibitions in the two preceding articles are applicable to sales in legal redemption, promises, and renunciation. Sunod naman tayo sa Chapter 3, Effects of the Contract when the thing sold has been lost. Article 1493, if at the time the contract of sale is perfected, the thing which is the object of the contract has been entirely lost, the contract shall be without any effect. Meaning, pag entirely na nawala yung contract, mawawala rin yung visa nito. But if that thing should have been lost in part only, the vendee may should choose between withdrawing from the contract and demanding the remaining part, paying its price in proportion to the total sum agreed upon. Article 1494, where the parties support a sale of specific goods and the goods without the knowledge of the seller have perished in part or have wholly or in a material part so deteriorated in quality as to be substantial change in character, the buyer may at his option treat the sale. Next ay Chapter 4, Obligations of the Vendor, Section 1, General Provisions. Article 1495, the vendor is bound to transfer the ownership of a delivery as well as a warrant the thing which is the object of the sale. In Article 1496, the ownership of the thing sold is acquired by the vendee from the moment it is delivered to him, in any of the ways specified in Article 1497 to 1,501, or in any other manner signifying an agreement that the possession is transferred from the vendor of the vendee. Next is Section 2, Delivery of the thing sold. It is comprised of Articles 1497 to Article 1544, which is the longest. Kung isa-isahin natin, Article 1497, the thing sold shall be understood as delivered where it is placed in the control and possession of the vendee. When the sale is made through a public instrument, the execution thereof shall be equivalent to the delivery of the thing which is the object of the contract in Article 1498. In Article 1499, the delivery of movable property may likewise be made by the mere consent or agreement of the contracting parties. In Article 1500, there may also be a traditional constitutum possessorium. In Article 1501, with respect to incorporeal property, the provisions of the first paragraph of Article 1498 shall govern. In Article 1502, when goods are delivered to the buyer on sale or return, to give the buyer an option to return the goods instead of paying the price. The ownership passes to the buyer of delivery, but he may revest the ownership in the seller by returning or tendering the goods within the time.
So next is Section 3, which is Conditions and Warranties. So Article 1545. So sabi dito. So hindi ko na babasahin. Sa madaling sabi, ang obligasyon ng dalawang panig sa kontrata ay dapat may isagawa. Halimbawa, sabi ng isang panig, ganito ang mangyayari, ngunit hindi naman ito nangyari. Maaari nang tumanggi dahil hindi naman ito nangyari ang nasabi sa kontrata. Pwede na siyang hindi magpatuloy sa isang kontrata. So next is Article 1546. So hindi ko na rin babasahin. So sabi dito sa Article 1546 na anumang paraan na pagpupromote sa kanilang produkto na wala namang patunay na ang gusto lamang ay akitin o kunin ang atensyon ng mga mamimili, ito ay malino na warranty at ito ay nasasad sa Article 1546. So next is Article 1547, which is in a contract of sale, unless a contrary intention appears there is, first is, so sabi dito,
that he has a right to sell the thing at a time when the ownership is to pass. So, sabi dito. So, ibig sabihin, una, dapat ito ay granted. So, halimbawa, magbebenta ka ng kotse, ngunit hindi ito nakapangalan sa'yo. So, malaking problema yun dahil nga hindi sa'yo na ipangalan yun. Hindi pa sa'yo nakapangalan yun. So, ikangalawa, so, sabi dito, implied warranty that the thing shall be free from any hidden faults or defect or any charge. So, ayun nga, dapat alam ng buyer na iyon ay walang sira at charges dahil nga para maiwasan yung warranty or maisoli sa yung product na iyon. Article 1548. So, di ko na rin babasahin. Sabi naman dyan, maaari daw paalisin ang mga vendor kung ang pwesto ay nabili na. Ngunit maaari naman magsalita ang mga vendor kung sila ay papaalisin na nang wala sa oras at hindi sila binigyan ng palugit na araw para makalis. So, next is Article 1549. So, di ko na rin babasahin. So, malinaw na sinasabi dito sa Article 1549 na hindi na pwedeng umapila or lumaban ang mga vendor dahil ito ay nabili na at mayroon ng bagong may-ari. So, ayan. Next is Article 1550. So, di ko na rin babasahin. So, malinaw na sinasabi dito sa Article 1550, kapag natapos na ang ilang araw na palugit na ibinigay sa mga vendor ay malinaw na pwede na nila paalisin ang mga vendor dito dahil ito ay kanila ng pagmamay-ari. So, next is Article 1551. So, sabi dito, maaaring mapalis ang mga vendor kung ang mga ibinibenta nila ay mataas ang presyo dahil hindi sila sumunod sa patakaran na hindi paglagay ng buwis para hindi mataas ang bilihin. So, next is Article 1552. The judgment vendor debtor is also responsible for eviction in judicial sales unless it otherwise decreed in the judgment. So, next is Article 1553. So, sabi dito, maaaring mapawalang bisa ang pagpapalayas nito kung gagawin nila ito sa maling paraan. So, next is Article 1555. So, sabi dyan, kapag napagkasunduan kung sakaling walang pagpapalayas na magaganap, maaaring humingi ng demand ang mga bendi ayon sa sumusunod. So, sabi dito, maaari lang hilingin na ibalik ang dating presyo dahil nga binaba nila ang presyo upang mabilis mabenta. So, ayan. Next is Article 1556. So, di ko na babasahin. Sabi dito, kung sakali na dumating sa punto na wala nang magtiwala dahil nga doon sa pagpapaalis, maaari nitong hilingin at tanggalin na ang kontrata, ngunit kailangan nitong ibalik ang mga bagay na nakuha niya dito. So, next is Article 1557. So, ayon dito sa Article 1557 ay hindi pa tuluyan na mapapatupad ang warranty hanggat hindi pa ito na ibibigay ang huling pagsusuri. So, next is Article 1558. So, sabi dito sa Article 1558 na hindi daw masyadong kailangan ng formal ang warranty. Ang warranty niya lalo na kung siya ay napag-utusan lamang upang paalisin ang mga nagtitinda. So, ayun, next is Article 1560. So, di ko na babasahin. Sabi dito, para daw sa mga property na ibinebenta ngunit hindi matatanggal or mababago, maaari lamang nila itong i-cover at malinaw na sinasabi rito sa Article 1559 na hindi pagmamayari nito ng mga nagtitinda at wala ito sa kontrata. So next is subsection 2, which is warranty against hidden defects of or encumbrances upon the things sold. So Article 1561, hindi ko nababasahin. Sabi dyan, maaari daw managot ang vendor dahil sa mga defects na nakatago sa ibinebenta nila. Bagkus dapat nga nila itong bawasan ng presyo upang umangkop sa binibenta nila. So, yun. Second is Article 1562. Sabi dyan, sa pagbebenta daw ng mga goods ay may condition or kalidad na tinitingnan. Ayon sa sumusunod, dapat alam daw ito kung saan ito galing. Pangalawa is dapat daw yung description ay tama at naangkop sa produkto. So next is Article 1563. Sabi dyan, para daw sa nasabing patent or trade name na walang warranty, dapat daw ito ay mayroong stipulation of the contrary. So ano nga ba yung stipulation to the contrary? So ibig sabihin, dapat ito ay napagkasunduan ng kondisyon upang maging legally valid. So next is Article 1564. Sabi dito, para daw sa warranty or condition na pinapahiwatig tungkol sa kalidad at layunin sa paggamit ng produkto or goods. So ayan. Next is Article 1564. Sabi dito, para daw sa kontrata ng pagbebenta ay dapat guaranteed na ang mga ito at walang anumang defects para walang problema sa pagsusuri ng mga sample. So, next is Article 1565. Hindi ko nababasahin. Sabi dito, ayon sa Article 1561 to 1566 ay malayang pinapapili sa pagpapaalis at proposal sa pagbawas ng presyo dahil sa mga pinsala nito. So, next is Article 1568. Hindi ko nababasahin. Sabi dito, para daw sa mga bagay na binebenta na may defects at mali ay dapat daw ay wala na itong presyo at dahil din ito ay dapat ito din daw ay alam ng nagbebenta o ng vendor upang maiwasan ang pagsauli ng mga ito. So next is Article 1569. Para daw sa mga bagay na binebenta ng may sira at hidden defects ay malaya daw na humingi ng mas mababang presyo ang mga mamimili. So next is Article 1573. So sabi dito, para daw sa mga naunang article tungkol sa pagbebenta ng mga animals ay dapat daw applicable din sa ibang binebenta. So next is Article 1574. Dito sa pagbebenta ng mga animals ay walang warranty kahit sa anumang pamilya dahil malaya mo naman itong masusuri at lalo na kung ito ay nasa mabuting kondisyon bago mo bilhin. So next is Article 1578. So ayun nga daw, kapag daw ang nabili nating animals ay namatay agad sa loob ng 3 araw mula ng ating kunin ay mananagot ang vendor dahil nga marahil ito ay masakit na bago niya ibenta. So next is Article 1579. So sabi dito, so ayun nga, hindi na daw pananagutan ng vendor ang nabenta nitong animals lalo na yun ay dahil sa kapabayaan ng bumili. So next is Article 1580. So sabi dito, sabi nga doon sa Article 1567 ay malaya ng magbawas ng presyo dahil nga doon sa defects, maaari lamang itong magamit sa parehong panahon kung kailan nakuha. So next is Article 1581. So sabi dyan, para daw sa pagbebenta ng mga malalaking baka ay dapat daw ipakonsulta or governed by the special law. So, ayan. Next is Chapter 5, which is obligation of the vendee. So, sabi dito, Article 1582. So, ayun. Dapat nga daw bayaran or upahan ng buyer ang delivery bukod pa dun sa kanilang bagay na binili. So, next is Article 1583. So, sabi dito, pwede daw tumanggi ang buyer para sa installment ng delivery, which is may separate pa na bayad. So, ayan. Next is Article 1584. So, di ko na babasahin. Sabi dito, so, para naman daw dun sa mga bagay na ibinebenta sa'yo, which is hindi mo naman ito in order. Halimbawa, sa mga naglalako, wala naman kayong agreement, kaya pwede mo siyang hindi bilhin. So, ayan. Next is Article 1585. So, di ko na rin babasahin. So, ayun. So, ayun nga daw, dapat daw tanggapin ito ng buyer kahit na hindi niya pa ito physically na nasuri. Halimbawa, umorder ka via online. Hindi naman natin ito nasusuri physically, pero pwede naman natin itong ibalik kung sakaling ito ay may sira. So, next is Article 1586. So, ayun nga daw, hindi na daw pananagutan ng seller ang kanyang ibinenta kung ito ay lumampas na sa napagkasunduan na araw ng warranty. So, next is Article 1587. So, sabi dyan, hindi na daw pwede tanggihan ng buyer ang kanyang in-order dahil ito ay napagkasunduan na. At dahil na din siyempre sa effort ng delivery. So, next is Article 1588. So, sabi dito, kapag daw walang agreement na nabanggit sa Article 1523 ay hindi na daw makatuwiran na ito ay mailagay or tanggapin niya. So, ayan. Next is Article 1589. So, dapat daw bayaran ng bendi ang interest para sa delivery ayon sa sumusunod. Una is dahil ito ay required at parte ng agreement. 2 is, should the thing sold and the delivery produce fruit or income. 3 is, should he be in default from the time of judicial or extrajudicial demand for the payment of the price. So, next is Chapter 6, which is action for breach of contract of sale of goods. So, next is Article 1597. So, sabi dyan, kapag daw ang mga goods ay hindi dumating sa tamang oras or kontrata at kinansilan ng buyer ang kanyang binili at dahil daw wala silang kakayahang gumpanan ang kanilang obligasyon, maaari daw tanggalin ang kanilang kontrata sa pagbebenta. So, ayan. So, sabi naman dito sa Article 1598, di ko na babasahin. Parang ganun lang din naman siya sa Article 1597, kung saan hindi dumating sa tamang oras ng kontrata, pwedeng mag-set up ng action si buyer against sa seller dahil nga sa breach of warranty. So, next is Article 1599. Where there is a breach of warranty by the seller, the buyer may accept or keep the good and set up against the seller dahil nga sa pagbawas or extinction of the price. Second is accept or keep the goods and maintain an action against the seller for the breach of warranty. So, ayan. Next is Chapter 7, which is extinguishment of sale. So, Article 1600. So, sabi dito, tulad ng mga naunang mga article, meron itong sanhi at obligasyon tulad ng mga naunang article. So, next is Section 1, which is conventional redemption. So, next is Article 1601. So, sabi dito, matutubos lamang ang vendor ang kanyang ipagbibili kapag makakaya na nitong sumunod para sa patakaran ng Article 1616. So, next is Article 1602. So, sabi dito, the contract shall be presumed to be an equitable mortgage. So, una, when the price of sale, right to repurchase is usually indicated. When the vendor remain in the possession or lease or otherwise. When upon or other expiration of the right to purchase other instrument extending to the period of redemption or guaranteeing a new period is executed. So, next is Article 1604. The provision of Article 1602 shall also apply to a contract purporting to be absolute sale. So, next is Article 1605. So, sabi dyan, para sa tinutukoy sa Article 1602 at 1604, maaaring humiling ang vendor para sa reformation of the instrument. So, next is Article 1606. So, sabi dyan, para daw sa karapatan na tinutukoy sa Article 1601A, dahil sa kawalan ng malinaw na kasunduan, karaniwang ito daw ay tumatagal lamang sa loob ng 4 na taon mula sa umpisa ng kontrata at hindi maaaring lumampas ng 10 taon. So, next is Section 2, which is legal redemption. So, Article 1619. So, sabi dyan, magiging legal lamang ang pagtubos kung ito ay may matibay na titulo. So, next is Article 1620. So, sabi dyan, pwede na raw itong tubusin kung sakaling ibenta ng co-owner ang kanyang parte rito. So, next is Article 1623. So, sabi dyan, hindi pa daw pwede tubusin ito sa loob ng 30 days sa legal na paraan dahil hindi ito maitatala na iyon ng pagmamayari unless nagbigay ng affidavit ang vendor paunawa sa mga ito. So, next is Title 7, which is barter or exchange. So, Article 1638. So, sabi dito, sa pamamagitan ng kasulatan or kontrata ng dalawang partido sa barter ay magsisilbi itong legal na paraan upang ipasa or ilipat ang titulo sa bagong may-ari. So, next is Article 1639. So, sabi dito, kapag daw nailipat na ang ipinangako sa kanya sa barter at ito ay dapat may patunay na ito ay hindi na kanyang pagmamay-ari.
In continuation, Chapter 2, List of Rural and Urban Lands. Section 1, General Provisions. Article 1646, the persons disqualified to by referred to in Articles 1490 and 1491 are also disqualified to become lessees of the things mentioned therein. Article 1647, if a lease is to be recorded in the registry of the property, the following persons cannot constitute the same without proper authority. The husband with respect to the wife's parapernal and real estate, the father or guardian as to the property of the minor or ward, and the manager without special power. Article 1648, every lease of real estate may be recorded in the registry of property. Unless a lease is recorded, it shall not be binding upon third persons. Article 1649, the lessee cannot assign the lease without the consent of the lessor, unless there is a stipulation to the contrary. Article 1650, when the contract of lease of things, there is no express prohibition, the lessee may sublet the thing leased in whole or in part without prejudice to his responsibility for the performance of the contract towards the lessor. In Article 1651, without prejudice to his obligations toward the sublessor, the sublessee is bound to the lessor of all acts which refer to the use and preservation of the thing leased in the manner stipulated between the lessor and the lessee. Article 1652, the sublessee is subsidiarily liable to the lessor for any rent due from the lessee. However, the sublessee shall not be responsible beyond the amount of rent due from him. In accordance with the terms of the sublessee, at the time of the extrajudicial demand by the lessor, payments of the rent in advance by the sublessee shall claim is concerned unless said payments were affected in virtue of the custom of the place. Article 1653, the provisions governing warranty contained in the title of sale shall be applicable to the contract of lease. In the cases where the return of the price is required, reduction shall be made in proportion to the time during which the lessee enjoyed the things. Section 2, Rights and Obligations of the Lessor and the Lessee. Article 1654, the lessor is obliged, first, to deliver the thing which is the object of the contract in such a condition as to the render it fits for the use intended. Second, to make on the same during the lease all the necessary repairs in order to keep it suitable for the use to which it has been devoted unless there is a stipulation to the contrary. Third, to maintain the lessee in the peaceful and adequate enjoyment of the lease for the entire duration of the contract. Article 1655, if the thing lease is totally destroyed by a fortuitous event, the lease is extinguished. If the destruction is partial, the lessee may choose between a proportional reduction of the rent and a rescission of the lease. Article 1665, the lessee shall return the thing lease upon the termination of the lease as he received it, save what has been lost in impaired by the lapse of time or by ordinary wear and tear, or from inevitable cause. Article 1666, in the absence of a statement concerning the conditions of the thing at the time the lease was constituted, the law presumes that the lessee received it in a good condition unless there is a proof of the contrary. Article 1667, the lessee is responsible for the deterioration or loss of thing lease unless he proves that it took place without his fault. This burden of proof on the lessee does not apply when the destruction is due to an earthquake, flood, storm, or other natural calamities. Article 1668, the lessee is liable for any deterioration caused by members of his household and by guests and visitors. Section 3, specialized provisions for the lease of rural lands. Article 1680, the lessee shall have no right to a reduction of the rent on account of the sterility of the land lease, or by reasons of the loss of fruits due to ordinary fortuitous event. But he shall have such right in case of the loss of more than one half of the fruits through extraordinary and unforeseen fortuitous events, save always when there is a specific stipulation to the contrary. Extraordinary fortuitous events are understood to be fire, war, pestilence, unusual flood, locust, earthquake, or other which are uncommon and which the contracting parties could not have reasonably foreseen. Article 1681, neither does the lessee have any right to a reduction of the rent if the fruits are lost after they have been separated from their stock, root, or trunk. The lease of a piece of rural land, when its duration has not been fixed, is understood to have been for all the time necessary for gathering of the fruits which the whole state lease may yield in the 1 year, or which it may yield once, although 2 or more years have to elapse for the purpose. Article 1683, the outgoing lessee shall allow incoming lessee or the lessor the use of the premise and other means necessary for the preparatory labor for the following year, and reciprocally the incoming lessee or the lessor is under obligation to permit the outgoing lessee to do whatever may be necessary for the gathering or harvesting and utilization of the fruits, all in accordance with the custom of the place. Article 1684, land tenancy or shares shall be governed by the special laws, the stipulation of the parties, the provisions of the partnership, and by the custom of the place. Section 4, special provisions of the land lease of urban lands. Article 1686, in default of a special stipulation, the custom of the place shall be observed with regard to the kind repairs on urban property for which the lessor shall be liable. In case doubt, it is understood that the repairs are chargeable against him. In Article 1687, if the period of the lease has not been fixed, it is understood to be from year to year if he rent agreed upon is annual, from month to month if it is monthly, from week to week if the rent is weekly, and from day to day if the rent is to be paid daily. However, even though a monthly rent is paid and no period for the lease has been set, the court may fix a longer term for the lease after the lessee has occupied the premises for over 1 year. If the rent is weekly, the court may likewise determine a longer period after the lessee has been possession for over 6 months. In case of daily rent, the court may also fix a longer period after the lessee has stayed in the place for over 1 month. Article 1688, when the lessor of a house or part thereof used as dwelling for a family, or when the lessor or store or industrial establishment also leases the furniture, the lease of the latter shall be deemed to be the duration of the lease on the premises. Chapter 3, Work and Labor. Section 1, Household Services. Article 1689, household service shall always be reasonable, compensated. Any stipulation that household service is without the compensation shall be void. Such the compensation shall be in addition to the house helpers, lodging, food, and medical attendance. Article 1690, the head of the family shall furnish free or charge to the house helper suitable and sanitary quarters, as well as adequate food and medical attendance. If the house helper is under the age of 18 years, the head of the family shall give an opportunity to the house helper for at least elementary education. The cost of such education shall be a part of the house helper's compensation unless there is a stipulation to the contrary. Article 1692, no contrary for household services shall last for more than 2 years. However, such contract may be. Article 1693, the house helper's clothes shall be subject to stipulation. However, any contract for household service shall be void if thereby the house helper cannot afford to acquire suitable clothing. Article 1694, the head of the family shall treat the house helper in just a humane manner. In no case shall physical violence be used upon the house helper. In Article 1695, house helper shall not be required to work more than 10 hours a day. Every house helper shall be allowed 4 days vacation each month with pay. Article 1696, in case of death of the house helper, the head of the family shall bear the funeral expenses if the house helper has no relatives in the place where the head of the family lives with sufficient means therefore. Section 2, Contract of Labor. Art 1700, the relation between capital and labors are not merely contractual. They are impressed with the public interest, and the labor contracts must yield to the common good. Therefore, such contracts are subject to the special laws on labor unions, collective bargaining, strikes, and lockouts. Closed shops, wages, working conditions are of labors and similar subjects. Neither capital nor labor shall act oppressively against the other or impair the interest or convenience of the public. Article 1702, in case of the doubt, all labor legislations and all labor contracts shall be construed in favor of the safety and decent living for the laborer. In Article 1703, no contract which practically amounts to involuntary servitude under any guise whatsoever shall be. In Article 1704, in collective bargaining, the labor union or members on the board committee signing the contract shall be liable for non-fulfillment thereof. Article 1705, the laborer's wages shall be paid in legal currencies. Article 1706, withholding of the wages except for debt due shall not be made by the employer. Article 1707, the laborer's wage shall be a lien in the good manufactured of the work done. Article 1708, the laborer's wages shall not be subjected to execution or attachment except for the debts incurred for food, shelter, clothing, and medical attendance. Section 3, Contract for a piece of work. Article 1713, by the contract for a piece of work, the contractor binds himself to execute a piece of work for the employer in consideration of a certain price or compensation. The contractor may either employ only his labor or skill or also furnish the material. Article 1714, if the contractor agrees to produce work from material furnished by him, he shall deliver the things produced to the employer and transfer the dominion over the thing. This contract shall be governed by the following articles, as well as by the pertinent provisions on warranty of title and against hidden defects of the payment of price in contract of sale. Article 1715, the contract shall execute the work in such a manner that it has qualities agreed upon, and defects which destroy or lessen its value or fitness for its ordinary or stipulated use. Should the work be not of such quality, the employer may require the contractor remove the defect or execute another work. If the contract fails or refuses to comply with the obligations, the employer may have the defect removed or another work executed at the contractor's cost. Article 1716, an agreement waiving or limiting the contractor's liability for any defect in the work is void if the contractor acted fraudulently. Article 1717, in the contractor bound himself to furnish the material, he shall suffer the loss of if the work should be destroyed before its delivery, save when there has been delayed in receiving it. Section 4, Common Carry, Subsection General Provisions. Article 1732, Common carries are persons, corporations, firms, or associations engaged in the business of carrying or transporting passengers or goods or both by land, water, or air, for compensation offering their services to the public. Article 1733, common carriers from the nature of their business and for reasons of public policy are bound to observe extraordinary diligence in the vigilance over the goods and for the safety of the passengers transported by them according to all the circumstances of each case. Such extraordinary diligence in the vigilance over the goods is further expressed in Articles 1734, 1735, and 1745, numbers 5, 6, and 7, which the extraordinary diligence for the safety of the passengers is further set forth in.